contrary to federal guidelines, a federal appeals court has decided that Texas hospitals are not allowed to perform emergency abortions in order to stabilize a patient's life. Together with the Christian Medical and Dental Associations, the American Association of Pro-Life Obstetricians and Gynecologists, and Texas Attorney General Ken Paxton, the Fifth Circuit Court of Appeals took Ken Paxton's side. The judges ruled in their ruling that the state laws are in contrast with the Biden administration's guidelines, which states that hospitals covered by Medicare should perform abortions if they provide required stabilization treatment. Decisions made by the court may be challenged on appeal, and any party may ask the U.S. Supreme Court to hear the case. In an email on Wednesday, the Justice Department declined to comment on the rulings. In a statement following the Circuit Court's rulings, Alliance Defending Freedom Senior Vice President Ryan Bangert stated that emergency rooms, specifically, are tasked with stabilizing lives. The Fifth Circuit rightly recognized that the federal government has no business turning hospitals into abortion clinics. Under Texas law, an abortion is prohibited when a pregnant patient has a life-threatening condition or faces a serious risk of a substantial bodily function impairment. This situation is referred to as an emergency and does not apply to confined situations. With the 2022 Dobbs v. Jackson Women's Health Organization verdict reversing Roe v. Wade worldwide, Texas became the largest state to pass restrictive abortion laws, and as a result, the state built a legal framework surrounding the process. 20 women who had been denied abortions in Texas filed a second, ongoing lawsuit seeking nearly total relief from the state's abortion ban. In November, attorneys made oral arguments before the Texas Supreme Court in anticipation of a ruling. The Texas Medical Board chose to rely on the legislature for guidance on abortion laws, despite the state's highest court's recommendation last year that the board provide doctors with such information. In an interim statute, the legislature made it clear that physicians are permitted to perform abortions in circumstances involving two particular life-threatening pregnancy disorders. In response to the Dobbs ruling, the Centers for Medicare and Medicaid Services and the U.S. Department of Health and Human Services issued their own guidelines, which said that hospitals should perform abortions if doing so is medically necessary to stabilize a life-threatening condition and is within their purview. Act of 1986 on Emergency Medical Treatment and Active Labor. A Justice Department attorney contended before the court in November, following the filing of the lawsuit against Texas and anti-abortion organizations, that the guidelines represented a troubling deviation from the essential principle of patient safety in Texas.